This is our Fall Successor Trustee Workshop. As those of you who have been here before know, we do this in the fall and in the spring. And the purpose of this is twofold. One, to provide you with a refresher on what a revocable living trust is all about. And the second, to provide you with some instruction of what to do if you are a successor trustee. Our objectives with this seminar is to demystify the role of the trustee and the trustee's duties. We want to prepare you for performing the roles and duties effectively and efficiently, and we will address any of your questions and concerns. As we go through, we'll ask for your questions. If you've got any questions just while I'm presenting, it's fine to just raise your hand and ask it, rather than try to hold on to it until we're finished. These are the topics we're going to cover today: the law, documents and fiduciary roles, the role of a disability trustee, the role after the death of a trust maker, how to handle different types of assets in a trust estate, the ever wonderful taxes, management of assets, liabilities, and resources for your assistance. Your documents. This is our refresher. You all have a copy of your trust portfolio. It's either green or in some cases red if you've got an older version. Inside that portfolio are a number of documents. The first is your revocable living trust. This is by far your most important document. That's where all of your instructions are to your successor trustees and your beneficiaries about what happens to your assets upon your death or disability. The second document is a pour-over will. It's quite literally what it says it is. It pours over assets into your trust. We hope never to invoke that document, and we hope you all have your trusts fully funded. To refresh your recollection, fully funded means that you have all your assets titled one way or another in the name of your trust. If you have all your assets titled in the name of your trust, we will not have to use that pour-over will, and we will just have that pour-over will available in an emergency. The pour-over will does nothing more than probate your assets, if you have any in your own sole name upon your death, and put them into your trust. We have a durable power of attorney. Those for financial affairs. Those are for assets that can't be immediately, at least at this point, transferred into your trust. That would include things like your IRA. Your IRA eventually gets into the trust by means of a beneficiary designation, but at least initially it's not part of your trust assets. So durable power of attorney, one of the things that you can use, your power holder can use that for, is to handle your IRA assets. You also have healthcare documents. A living will, which tells your family and healthcare providers what your wishes are at the end of your life. Healthcare power of attorney, which says who can make healthcare decisions about you if you cannot make them yourself. And a HIPAA, Health Insurance Portability and Accountability Act, general release form that says who can get healthcare information about you if you become hospitalized. In your portfolio are some documents you should complete. I know you have always heard us tell you that you can't write on your trust documents. Well, there are other places in that portfolio where you can write. You can complete your memorial instructions. I can't tell you how many times family members have said to me, gee, I'm so glad Dad or Mom completed those memorial instructions. We knew right what to do. Complete your personal property memorandum. That's the document in your trust portfolio that says who gets what stuff. If you're one of my clients, you know that I always say, give your diamond-encrusted tiaras to Lee Mulligan. I've gotten 2 so far. I don't think they're real diamonds, though. Complete your PIN password information form. If some of you have not received that form as part of your signing package, call the office and we'll be happy to provide you with one. This is particularly important in case of bank accounts and so forth, where no one will have access to that PIN number unless you provide it to someone. Okay, this is a slide that's meant to clear up some confusion. I always have clients who say, they don't understand what the difference is from the various roles. In one plan, they may be named as a trustee. They may be also named as the attorney-in-fact under a durable power of attorney. They are named as the healthcare agent, and they might be named as the personal representative or executor under a will. Well, what does that mean? Well, whenever you have a role assigned to you, there is a document that goes along with that role that explains what your duties and obligations are in that role. So if you're named the trustee, your duties and obligations are spelled out in the trust. And that's what the document that you have to read to see what the limits of your authority are and the breadth of your authority is. If you're the attorney in fact, you would look at the durable power of attorney form to see what you can do with that form. Remember, if it's a trust, it has to be a trust asset for you to act as a successor trustee. If it's not a trust asset, you have to use another document to take control of that asset. So if someone is still alive but incapacitated, you would use the durable power of attorney. If someone is deceased and the asset is in their own name, you would use the will to take control as the personal representative or executor.